Ever wonder which law actually answers your HR question? Overtime, terminations, accommodation. In Canada, most workplace issues trace back to 3 sources. Learn them once, and you'll spot them fast forever. Here's the big picture. Employment law in Canada comes from statute law, constitutional law, and common law. This video focuses on non-unionized employment. Unionized workplaces mainly follow a collective agreement and the labor relations system. First, statute law. Laws passed by governments. Think about Ontario's Employment Standards Act and Human Rights Code, or federally, the Canada Labour Code and the Canadian Human Rights Act. Statutes set minimum standards, hours of work, overtime, public holidays, leaves, vacation pay, termination and severance, and protections against discrimination. You can't contract below these minimums. A contract can be more generous, never less. Statutes usually apply to both unionized and non-unionized employees. Second, constitutional law, mainly the Canadian Charter of Rights and Freedoms. The Charter protects fundamental rights against government action, so it applies to public sector employers, government bodies, and legislation. Private employers aren't usually directly bound by the Charter, but it still shapes statutes and court decisions that affect workplaces. Third, common law, judge-made law developed through court decisions. Common law fills the gaps, especially in employment contracts. A classic example is wrongful dismissal and reasonable notice when a termination clause is invalid or missing. Common law often borrows ideas from statutes, but it isn't the same thing. What about union versus non-union? If you're non-union, rights come from your contract, statutes, and common law. Disputes usually go to civil court or a tribunal. If you're unionized, rights come from the collective agreement and statutes, and disputes are handled through the grievance and arbitration process, not civil court in most cases. Let's make it practical with a quick scenario. An employee is terminated without cause. What do you check? Step 1. Statute. Confirm the Employment Standards Act minimums, notice or termination pay, and severance pay if the thresholds are met. Step 2. Contract. Is there a termination clause? Is it enforceable? If the clause tries to go below ESA minimums, or if it's poorly drafted, it may not stand. Step 3. Common law. If the termination clause is invalid or missing, the employee may be entitled to common law reasonable notice, which is often more than ESA minimums. Step 4. Human rights. Screen for discrimination, risks under the Human Rights Code, such as disability, family status, age, or other protected grounds. If this were a unionized workplace, you would start with the collective agreement and follow the grievance process. Here's a quick HR checklist. What is the issue? Standards, rights, or dismissal? Start with statute, then check the contract, then consider the common law. Is the workplace unionized? If yes, use the collective agreement and arbitration. Is it public sector? Consider charter impact. Always screen for human rights concerns. Myth versus fact. Myth. The charter applies to all employers. Fact. The charter mainly applies to the government and public sector actors. Private employers are generally governed by statutes and common law. So, who makes employment law? Legislatures make statutes. The Constitution sets the rules for governments. Courts develop the common law. Together, they create the framework you use every day in HR. If this was helpful, subscribe for more bite-sized HR law explainers. Disclaimer: this video is for education only and is not legal advice. Laws vary by jurisdiction and facts. For specific cases, speak with a qualified lawyer.